Hello and welcome. I'm Alison Garrett. I'm a senior legal advisor in the construction team here at Reeve, and I'm joined today by Duncan Astill, who's a partner here and head of health and safety. And today we're going to be talking about health and safety in the construction industry. Before we get going, there's a couple of housekeeping points to mention. Firstly, this webinar is being recorded, and the slides and recording will be available to you afterwards and will be sent to you afterwards. Secondly, if you have a question, please put it in the Q&A box on the screen, and we'll try to get through as many questions as we can at the end of the webinar. So, without further ado, what are we going to cover today? Well, I'm going to start by talking about particularly some FAR issues and duties in relation to FAR, and also some forthcoming changes that are going to take place in relation to FAR legislation. And then Duncan will see and discuss how that fits with other requirements that you may have, and going back to the basics of the overarching criminal law duties in respect of health and safety. I think we've all, to a certain extent, particularly in the construction industry, been focusing on FAR legislation recently, and perhaps overlooked the fact that a lot of what's happening in relation to legislation is just beefing up or reminding us to a large extent of what the position is generally with regard to health and safety. So as I said, I'm going to talk to you firstly a little bit mainly about FAR safety, and I say mainly in brackets because I think that there's a distinct possibility that some of the legislation that we're seeing at the moment, or proposed legislation, might in due course become wider than just FAR safety. And I'm primarily going to look at two things. I'm going to look at the roles and responsibilities of the responsible person and the accountable person. And then I'm going to look at some new legislation that's come into force in relation to FAR already, together with some points that the government is considering in relation to consultations in respect of FAR. And also, just lastly, I'll touch on some of the government's proposals for paying for the cost of remedial cladding before I hand over to Duncan to talk about health and safety in a more general frame. So as I said, I'm going to talk about the roles and responsibilities of the responsible person. The responsible person has actually been with us for about 15 years already. And I'm also going to consider the role of the accountable person, which is a person that's proposed by the Building Safety Bill. We don't as yet know exactly when that might become law, but it's anticipated that the Building Safety Bill might get royal assent sometime in the middle of next year. So, the responsible person. Just before I start talking a little bit about the responsible person, I want to mention the legislation that I'll primarily talk about today, because it all sounds, or at least to me, it sounds all very similar. I'm going to talk about the Regulatory Reform FAR Safety Order, usually known as the FAR Safety Order. I'm then going to talk about the FAR Safety Act 2021 a little bit, and then the big changes that are coming forward in the Building Safety Bill. So we're talking about the FAR Safety Order, the FAR Safety Act, and the Building Safety Bill. So firstly, the responsible person came into effect as a result of the Regulatory Reform FAR Safety Order 2005, usually just known as the FAR Safety Order. And you're required to have a responsible person in respect of non-domestic premises and the non-domestic parts of residential premises. So broadly speaking, and I'm being very broad here, the common parts of, for instance, a block of flats. There is no height requirement set out in the FAR Safety Order. I think those of us that have been dealing with FAR in the last few years have, to a certain extent, fixated on the height requirements of 18 metres or 6 or 7 stories, and sometimes 11 metres. But note, there is actually no requirement of any height under the fire safety order. The order sets out duties and responsibilities for the responsible person. It has been clarified following Grenfell, and I'll come on to talk about that in a little bit more detail in due course. And the Building Safety Bill that's going through Parliament at the moment increases or proposes to increase the duties on the responsible person. And I'll talk about that in a little bit more detail as well. So who is the responsible person? Well, the order talks about it referring to in the workplace, it will be the employer if the workplace is under the employer's control. If there is no workplace as such, then it is the person who has control in connection with carrying out of a trade, business or other undertaking, or the owner. Now, although I don't think it's entirely clear under the order, you can have more than one responsible person. And in fact, in cases I've been involved in, it's been, I was going to say a grey area, but it's been quite clear that there are probably two entities who should be treated as the responsible person. And that is correct. If you think that you're in doubt, or if you're having a discussion with somebody else as to whether you're the responsible person, the chances are you both are. You both have responsibilities. As I said earlier, there's been some clarification following Grenfell with the Fire Safety Act 2021. I mentioned that the fire safety order covers non-domestic premises and the non-domestic parts of residential premises. It was felt that there was some confusion in relation to the non-domestic parts of residential premises. So it's now been confirmed by the Fire Safety Act that the order covers the building structure, external walls and any common parts of a residential building, and all the doors between the domestic premises and the common parts. This door thing is primarily concerns in relation to flat entrance doors, and the fact there was some confusion or debate, or it was felt it needed clarifying, that flat entrance doors are covered by the fire safety order. I'm not proposing in the time we have available today to run through all the responsibilities of the responsible person, but what I have done is list a few of the things that are being tightened up by the Building Safety Bill, or proposed to be tightened up by the Building Safety Bill. It includes a tightening up of who can assist the responsible person in making or reviewing risk assessments. And this is a theme that you'll see when I talk about the accountable person as well. There is a move towards making it much more professional, shall we say, in terms of who is dealing with the responsible person's duties or assisting the responsible person with their duties. The bill also says that if there are two or more sets of domestic premises within a building, then there will be a requirement to give information to residents about fire safety matters. And again, when I talk about the accountable person, you'll see again there's a move to giving residents more information. There's also a requirement for the responsible person to keep records of fire safety matters. And yet again, when I talk about the accountable person as well, you'll see that there is a move towards making sure that there are records from the inception of a project all the way through to the end of occupation. When you come to the Building Safety Bill, it's called, often referred to as the golden thread of information available from the start to the finish of a building. And this is an example of the government putting into practice the golden thread idea. In addition, if there's more than one responsible person, so if there was any doubt about the number you can have, this is making it clear there can be more than one. They must cooperate and coordinate with each other. This is another thread that you see throughout the bill. The intention that any lack of communication that may have existed in the past is rectified, that there be sharing of information between responsible people. If there is a new responsible person, information must be provided to them as well. Again, this communication, dealing with this a gap potentially in communication. And finally, they must cooperate with all accountable persons. As I said, the accountable person is somebody new introduced by the Building Safety Bill. And I'll move on now to tell you a bit more about the accountable person. The Building Safety Bill requires an accountable person to be appointed, or there to be an accountable person, should I say, if there is a higher risk building. Well, if like me, you may have read that several times, it took me some time to realise that it doesn't say high rise. I know it clearly doesn't, but it says higher risk, not higher rise building. And that's important because although the government has indicated that a higher risk building will be a building that's 18 metres or at least 7 stories high and contains at least 2 residential units, the explanatory notes to the Building Safety Bill, which are very helpful, make it clear that the definition of a higher risk building could be changed in the future to include, for instance, single-storey buildings in areas of high flood risk. So although you may only need to appoint an accountable person once the bill becomes law for buildings, residential buildings over 18 metres in height, that may not always be the case in the future. It's no accident that this is called the Building Safety Bill and not fire safety, in my view. So who is the accountable person? Well, it's a person with a legal estate in possession of any common part or who is under a relevant repairing obligation for any common part. And it can be a management company. And it's quite clear from the legislation that there can be more than one accountable person. And indeed, that if there is more than one, there will be a principal accountable person. And that principal accountable person will be ultimately responsible, primarily responsible for many of the requirements under the bill, but they will need to consult with other accountable persons. Again, I'm not going to go into the full details of the duties of an accountable person, but I've just listed here some of the key ones. They must register new builds with the Building Safety Regulator before occupation, and they must register existing buildings within a transition period. Firstly, the Building Safety Regulator is a new concept under the Building Safety Bill. It will be run effectively by the Health and Safety Executive, and its overarching obligation is to ensure that safety requirements within the ambit of the bill are met. Second point to note is that I've said that the accountable person must register new builds with the Building Safety Regulator before occupation and existing buildings within a transition period. Well, what is that transition period? It looks as if it's going to be 12 to 18 months from royal assent. And as I said, we think royal assent will be the middle of next year. So we're looking at the back end of 2023. That is not fixed. That is just my best estimate at the present time. The accountable person must also apply for a building assessment certificate from the Building Safety Regulator, and that must be displayed prominently on the building. They must appoint a building safety manager to assist them in managing the risks that they're required to manage. That person has to be a professional, and they have to notify the Building Safety Regulator of who they propose to appoint as the building safety manager. The Building Safety Regulator can veto the building safety manager. So there's a clear attempt to professionalise and regularise who is responsible for these primarily fire-related safety issues. They must manage risk. They must produce a safety case report, which they must keep up to date, and they must produce a residents' engagement strategy. So lots to think about. That's all I'm going to say about the responsible person and the accountable person. I'll now move on, as I said, to talk a little bit about legislation that we've seen coming through in relation to FAR generally, before I hand over to Duncan, who will go back to talking about duties and responsibilities in a more general way. So just some fire legislation, safety legislation, if you haven't picked up, that you might want to note. This relates to new builds or where there is a material change of use. Now, be very careful, because a material change of use can be something that appears quite innocuous on the face of it. So if you are changing a building in any way, I would recommend that you check whether it is deemed to be a material change of use. So from December 2018 on such buildings, there's been a ban on the use of combustible materials in the external walls in high-rise residential buildings. That's buildings at 18 metres or above ground level. Sprinklers are required to be installed in individual flats in over 11, where the blocks are over 11 metres in height. Now, that's not very high. It's about 3 to 4 stories high. That came into force in November last year. And there must be way tracking for the fire service, again, in blocks of flats over 11 metres height. And that came into force last year as well, November last year. The government has also consulted on 3 other possible key changes. They haven't changed the law in respect of these at the moment, but I think there's every likelihood that they will. First is a ban on the use of combustible materials in the external walls of residential buildings over 11 metres in height, and possibly including hotels, hostels and boarding houses, which have not been covered to date. The ban on the use of metal composite material with a polyurethane core in and on external walls in all buildings of whatever height, and extending the ban to solar shading shutters. They in fact tried to do that in an earlier stage, but there was, I won't go into the details of this, but there was a challenge to this, which they've had to, which meant they've had to reconsider how to legislate in relation to that. So that's changes in the law, or potential changes in the law. Couple of final points for me to mention to you. You'll all be familiar with the cladding crisis that's ongoing, and the fact that there are remedial works taking place in respect of the removal of cladding, and that there is a building safety fund which the government is backing to remove some of this cladding. How are they proposing to pay for that? Well, the 2 possible ways of paying for the remedial works at the moment, or for the government to recoup the cost of the remedial work, should I say, is the residential property developer tax, which is proposed will come into effect from April 2022. It will be 4% on profits over 25 million. We heard fairly recently that it won't apply to non-profit housing companies. We're also aware of the proposed building safety levy, which would apply to new high-rise residential buildings, care homes and hospitals, which are over 18 metres or 7 stories in height, and would apply to developments seeking building control approval to start construction. We don't know any more of the details really about this at the moment. The government issued a consultation which closed on the 15th of October, and we're waiting to hear from them. It should be noted that in that consultation, one of the questions was whether in fact the levy should apply to hospitals. So it seems it is by no means certain that in fact it will apply to hospitals, or possibly even care homes, but we'll have to wait and see. That's all I'm proposing to say about fire safety. I'll hand you over to Duncan, who is now going to pick up general health and safety duties and where we are with them.
Helps if you're unmuted, doesn't it? So hello, everybody. So thanks very much for joining on this late on a Thursday afternoon. So as Alison said, I'm Duncan Astill. I'm a health and safety lawyer. So I'm going to look at some of the same issues really as Alison, but from a slightly different context. And sort of some of the motivation for doing that was reading this quote from a couple of weeks ago when the BBC spoke to the Deputy Commissioner of the London Fire Brigade, who was sort of complaining that they were starting to see developers deliberately designing and building buildings that are just below the 80-metre threshold with a view to basically putting in less intricate fire safety measures. And as Alison sort of said, that there's often situations where there's more than one duty on an individual or multiple individuals. So I sort of started to think, well, is the specific building regulations requirements that they're talking about really the best way of looking at it? So what I'm going to do is just take you through really a look at the sort of root of health and safety duties and explain to you why they're sort of more widely drawn and how they fit in really with the concept of the accountable person or responsible person that Alison's been looking at. So moving on to the next slide, we want to look at the sort of concept of control really, because that's the basis on which you could find yourself having duties in respect of a building, even outside of the specific, being specifically the responsible person within a specific set of legislation. So it's a concept that occurs quite a lot. Health and Safety at Work Act, Occupiers Liability Act, etc. There we go. There are a number of different places where this same concept of control imposes duties on people, companies as a result of the extent of that control. So let's take a couple of examples of that. So looking at the Health and Safety at Work Act and how it refers to control of premises. On the next slide, you'll see section 4 imposes a duty on each person who has to any extent control of premises to take such measures as is reasonable for a person in his position to take to ensure, so far as is reasonably practical, that the premises are safe and without risk to health. So it's drawn exceptionally widely to start that it's each and every person who has any extent the control of the premises. And there's nothing in that sort of excludes fire from the concept of safety in this context, and it sort of recognises that each and every person. This isn't the case that someone there's a sort of baton for safety, for fire safety or health and safety that you pass from one person to another. Basically, multiple parties can each be responsible for the safety of premises, whether you're owner, occupier, contractor, etc., but only to the extent that it's reasonable by reference to the extent of control you have. And so that has led to, examples where freehold owners have been prosecuted in respect of leased buildings. A tenant with no repair rights has still been held to be in control of premises, in particular the access and use of the premises, and therefore could have, for example, fenced off an unsafe bit of the building to stop people being injured. So that in particular example was under the workplace regulations. But if we move on to the next slide, there's also a similar obligation included in the fire safety order. So you see I've termed them there the also responsible persons, because regulation 5.3 says any duties imposed under the fire safety order, so this is what you have to do to comply with the fire safety order regulations 8 to 22, shall also be imposed on every person other than the responsible person who has to any extent control of those premises so far as they relate to requirements within his control. So in effect, it's a similar duty to that section 4.1, that the extent to which you're in control of any premises means you also have the same duties as the responsible person to make sure that appropriate arrangements are put in place to mitigate the risk of fire. So, just because there is a responsible person under the fire regulations doesn't mean that you don't have duties in respect of fire safety that are commensurate with your relationship with the building. So if we look at the next slide, that's spelt out then in Regulation 5.4 of the order as well, that says, even if you're the extent of your obligations in respect of maintenance or repair or the safety of any premises, then you are a person who's in control of the premises to that extent. So the sort of government guidance on this sort of makes it clear that someone carrying out, for example, a fire risk assessment, or a fire alarm engineer, someone who's just simply coming to the premises to maintain or repair or implement or assess what safety measures are required, has a duty under that section 5.3. So if you're inadequate in the way you're maintaining equipment, or the results of your fire risk assessment is inadequate, then you could be breaching that offence as well. So in summary, if you have control, you're going to have some obligation as well, and control, working out whether you have control, means really looking at a number of different factors, looking at the rights you have over the premises, the extent to which you have any practical control, presence or lack of premises on the building, the extent to which control has been transferred to someone else, and the extent to which it's foreseeable that any failure on your part to do something could result in injury. And what that's led to is that in certainly some cases that I've been involved in, clients have gone, perhaps much further than you would have expected, that to put in place, for example, nighttime fire watchers within residential buildings, because they're not confident the existing measures are sufficient, and they have control of the premises to the extent that they can put in a fire watch. And certainly the argument is yet to come about who's going to pay for that, and whether it's the original developer, the owner, or whether it's the tenant. But it is a very, very wide obligation. But if we move on to the next slide, there's also a sort of even more fundamental obligation on you. And I've sort of put my apology up there to start with, that I do just need to take you through a little bit of law so you can fully understand this point. The legislation, there are different there's a different hierarchy really of legislation. So there are acts of parliament, which is the sort of primary legislation, statutory instruments, which is secondary legislation. Effectively, the act gives another party, usually the minister, the power to bring in secondary legislation to sort of fill in the details of the acts basically, and provide greater guidance on how you comply with the overarching duty that's created by the Act of Parliament. So in a health and safety context, it's the Health and Safety at Work Act, if we move on to that next, that sets out this overarching duty. You'll see it's sort of nearly 50 years it's been in force, and sets out this general duty on employers and self-employed to ensure the health, safety and welfare of all his employees, but also very importantly in section 3, that persons not in his employment who may be affected thereby are not thereby exposed to risks to their health and safety. So that duty is so broadly written that you can see that a company that, for example, lets residential property owns a building and sort of, manages that building, lets it out, would have duties both under Section 2 to its employees working in that building, but also under Section 3 to anyone who's resident in that building to ensure that it's safe. So that would equally apply to fire risks as well as any other risks. So making sure that there aren't tripping hazards, there aren't the lifts work, all of these things that are involved in running a business. But whilst it's an absolute duty, you have to ensure the health, safety, and welfare of those individuals. It is a defence if you, and it is a reverse burden of proof, can prove to the satisfaction of the court that you took all reasonably practicable steps to achieve that duty. So irrespective of all the sort of the regulations, the fire safety order, etc., this is an overarching duty that will always be on you, provided you are an employer or self-employed, that you have to be able to demonstrate that you've done everything that was reasonably practicable to do in those situations. So compliance with a specific set of regulations would be, we appear to have lost Alison there, and therefore the slides. But if I just sort of carry on. So that's the overarching duty. Health and Safety at Work Act ensure health, safety, and welfare of everyone affected by what you get up to. If you've complied with the regulations, the specific set of regulations, such as the fire safety order or the control of substance hazard to health regulations, whatever it happens to be, then that's certainly going to be a very argument. It's going to be a very good basis for saying that you've complied with the overarching duty under the Act. The saying goes, if you've been complying with the building regulations, compliance with, you're selecting material that it meets British standards, certain technical specifications, guidance, etc. But it's certainly not the same as having taken all reasonably practical steps. It's basically a solid basis for mounting that defence. But there may well be situations where it could be argued that you have to go further. That there is an obligation on you to do more than perhaps it says in the building regulations or guidance. So if we sort of take a specific example there, if we take sprinklers that was mentioned earlier by Alison, there's a requirement under the building regulations that if a building is over 11 meters, then you've got to have sprinklers. But if you look at sprinklers, there is evidence to say that they're 99% effective at controlling or extinguishing fires. So clearly something that is very effective as a control measure. And then if you look at at a particular look holistically at a building and the sort of risk to the occupants of that building, if you look at the functions that the building's going to be used for, is it office space, is it retail, residential, is it a warehouse, storage, etc. You look at the occupation, who's going to be in there, and the vulnerability of those people in the building, the combustibility of any material in the building, or indeed sources of ignition that may be generated by the use that the building's put to. Look at the construction methods of the building itself, even the fire service response time. It might be very, very difficult to argue that even though the building is only 10 meters high or whatever, it may be very difficult to argue that it wasn't reasonably practicable, given the nature of the risk generated by that building and all those factors, that it wasn't reasonably practicable to put a sprinkler system in. So if we go back to the sort of 17.9 meter building, and the quote from the fire service at the start, it may be right that the mandated additional requirements don't strictly apply to a building that is less than 18 meters, but the onus on all those in control, the owner, the designer, etc., to take all reasonably practical steps, you might find that it's really difficult to persuade a court that 10 centimetres made a real world difference, and that it wasn't reasonably practicable to implement some of those same measures that are compulsory in respect of a building of above 18 metres. So I think in summary, whilst there is, obviously you've got to comply with those specific legal duties that are set out in fire safety regulations, the building regulations, etc. Don't forget that you have this overarching duty under the Health and Safety at Work Act to ensure the health and safety of everybody, and that certainly could come back to bite you if you are not taking, to the extent that which you have control and influence on that, you're not taking that into account in terms of the safety of the users of that building. So that was all I wanted to say. Sorry, Alison, you obviously had a bit of an IT hiccup there. So.
Internet problems, which I'm still trying to resolve. But it's always the way that things happen like that, isn't it? When you least
Absolutely.
expect it.
So I sort of carried on and sort of finished my bit, and obviously the slides are available, will be sent out to everybody afterwards. So so if we move on now, if anybody's got any questions, there should be at the bottom of the screen the Q&A function, if anyone's got any particular burning questions in light of what we've talked about this afternoon.
There's one question about what we should do about the building safety bill in terms of drafting, what we can do at the moment. It should be included in construction contracts, and I think probably we should be thinking about making it clear that it's legislation that's in contemplation when we're drafting construction contracts, that we now have a fairly good idea what will be in the building safety bill, or however many hundreds of pages of it that there is. If you think you've got a higher risk building, you may want to refer to that for the sake of clarity. And if you have, then I think it would be wise to say who you think the principal accountable person is, to avoid the sort of issues that I think both you and I, Duncan, have seen in the past with who the responsible person or persons might be.
Mm-hmm.
All of those need to be sensible precautions going forward.
And just a question for me, Alison, on that. Although you can sort of, we clearly know at this stage there is a bill before Parliament in terms of the building safety bill. Is there something that, how far can you protect yourself if you're right that this is going to extend to lots of other requirements? So if that bill ultimately becomes an act and then in due course gets extended to cover all sorts of other aspects of building safety, such as flood risk for buildings of any height, is there anything you can do to protect yourself now in respect to future changes that to that particular bit of legislation?
I think it's quite difficult because it all really hinges at the moment on the definition of higher risk building, and at the moment the government is saying that is 18 metres or 7 stories, and when you've got more than 2 residential premises. I don't see how you're going to be able to define at the moment something that might be higher risk when you don't know what they've got in mind. They're obviously concerned about flood risks and the like, but that linked, I suspect, with climate change and net zero. But it's a bit trying to crystal ball gaze, I think, to go any further than that at this stage.
Yeah.
Some other. Sorry.
Yeah, well, I was going to say, so we've had a question come in asking about what level of responsibility would a university have in relation to student accommodation when only referring students to private accommodation. So, I mean, that is one that we have seen before, and I think it is difficult if you look at it from what we've been looking at today. Then clearly, you often would have no rights to even cross the threshold of the building. No rights to enter the building or carry out any kind of extent. So your control of the building is pretty limited in terms of making any changes or assessing compliance. But I would say if we go back to the overarching duty of the Health and Safety at Work Act as set out, under Section 3, you have a duty to ensure that those affected by your undertakings, other than your employees, so those students, are not exposed to any risks to their health and safety. So I think there is an onus on the university to make sure, or take some steps to get assurance from the provider of accommodation that appropriate safety measures are in place in the building, that there is an appropriate fire strategy, that there aren't any obvious problems with the building, that there are there is regular maintenance going on, that there is a regular update to the fire risk assessment, etc., etc. They're just some basic steps to make sure that you are referring students to a sort of a building that is appropriately managed and safe.
And I think, and here I am sort of, if not quite making up the law as I go along, but something that you could do when the Building Safety Bill comes into force, is there's this concept, this idea that if the accountable person isn't behaving in the way they should do, then the building safety regulator can step in and put in a special measures manager. Now, I can't tell you off the top of my head when the building regulator might think that's appropriate, but I suspect that's going to be a mixture of the building regulator investigating or visiting premises itself and or those potentially on the sidelines that are affected, notifying the building safety regulator that they have concerns. Do you have any thoughts on that, Duncan? I think how it's going to work.
I mean, certainly the bringing in a sort of a documentation sort of regime that there is a certificate, and people will I'm sure remember, or some people. Perhaps you're all younger than me, but remember the concept of a fire certificate, that you couldn't occupy a building without a fire certificate from the local authority. And so I suppose that would be one of the key documents you would want to see, wouldn't you? That the building has been assessed and signed off. But then so another question that's come up is about sort of refurbishment of building, and to what extent the project manager has duties, and I think that's going to depend really on what role, what function the project manager is fulfilling. So if the project manager is managing the procedural steps, and only the sort of procedural steps, etc., and aren't making any decisions around designing the building, what safety measures to put in, what control measures, etc., etc., then they're going to have a relatively limited set of liability. But if the project manager, in the same way that a client starts making design decisions, if the project manager starts making design decisions and starts to the extent that they are influencing the control measures that are put in place, the way in which that building is refurbished. And so, for example, if the project manager were to say, no, we're not having a sprinkler system, then they might well be have a duty or some responsibility for that decision should something go wrong.
Yes, and there's one more question here, Duncan. Who would typically act as the accountable person? What profession? Well, I think the accountable person is going to be somebody who's got a legal interest in the premises. So they can't, it's not a profession as such, but who they appoint as the building safety manager to help them will be a professional as such, and it will probably be somebody with experience in fire safety. I can't see how it can't be that, because if it has to be, or it can be vetoed by the building safety regulator if it's not somebody considered suitable. And it seems to me it's got to be somebody probably with a background in health and safety and or fire.
So it's probably a quirk of the way that the legislation's drafted, isn't it? That
Yes.
person doesn't mean a living person, as it were. It means a legal entity. So whether that's an individual person, but in most cases, if the building's owned by a company or the lease is given to an organisation, as it were, it will be that company or organisation that is the accountable person, and it's their job then to take the appropriate steps.
Yes.
And that may well be by appointing a person to do it, but but yeah.
Yes, it's something that the fire safety order did with responsible persons as well, and it's slightly odd phraseology, I find, for both in both instances. It's not what you'd expect, but it's not a person as such usually, anyway.
Yeah.
But
so
but the entity has duties and responsibilities which it will usually use a building safety manager to help it comply with.
Yeah. So it's just a quirk of legislation drafting that they use person to mean legal entity, really.
And how this will work in practice, because I don't know how many building safety managers with appropriate qualifications there are out there at the moment, and a lot of professionals who've got experience of fire safety are busy advising in relation to cladding claims, and there's a shortage of them anyway. So pragmatically, it's not quite clear how this will work. In practice.
But yeah, maybe it's the time to get on some courses quick.
Those are the only questions we've got outstanding. I think perhaps the overall thing that Duncan and I would like to get across is, don't get hung up on the building safety bill or indeed the fire safety order. Duties are much wider than that anyway, and so don't narrow them down. Be aware of the building safety bill. Be aware of the requirements for an accountable person and what they will need to do going forward, because we're just going to see more and more of that. But it's not the be-all and end-all of health and safety in the construction industry. Duncan, do you have anything to add to that?
Not at all. Hopefully that's been useful. And again, thanks very much for joining us. And happy Christmas.
Happy Christmas.